A law that just took effect could turn your concealed carry permit into a useless piece of paper. And in less than 60 days, another change could make you a criminal without even knowing it. Before we dive in, do me one favor. Hit that subscribe button right now. Why? Because 90% of gun owners miss critical legal updates like this, and I don't want you to be one of them. These changes are happening fast, and if you're not paying attention, you could end up in serious legal trouble. So click subscribe, and let's get into it. Okay, here's what's going on. Right now, in 2026, we're seeing the biggest shift in gun laws since the Supreme Court's Bruin decision back in 2022. 5 major changes are either already in effect or coming very soon. And if you carry concealed, every single one of these affects you directly. Let me break down what's happening and what you need to do about it. First thing, let's talk about the National Firearms Act tax change that just went into effect on January 1st, 2026. This is huge, but most people don't understand what it means. Here's the deal. Congress passed something called the One Big Beautiful Bill Act. That's its actual name. And buried inside this law is a massive change to NFA firearms. NFA stands for National Firearms Act. These are heavily regulated items like suppressors, short-barreled rifles, and short-barreled shotguns. For decades, if you wanted to buy one of these items, you had to pay a $200 tax stamp to the ATF. That's the Bureau of Alcohol, Tobacco, Firearms, and Explosives. You'd fill out paperwork, get fingerprinted, wait months for approval, and then finally get your tax stamp. Well, as of January 1st this year, that tax is now $0. For suppressors, short-barreled rifles, and short-barreled shotguns, 0. But here's the catch, and this is the part nobody's talking about. You still have to do all the other stuff. You still need to register the item with ATF. You still need fingerprints and photos. You still need to wait for approval. The only thing that changed is the tax amount. Now, why does this matter for concealed carry holders? Because there are already 2 major lawsuits challenging the entire NFA system now that the tax is gone. These lawsuits argue that Congress only had the power to regulate these items because of the tax. It was a revenue thing. But now there's no revenue. So the lawsuits say the whole registration system is unconstitutional. If these cases win, it could completely change how suppressors and short-barreled firearms are regulated. But if they lose, we're stuck with all the red tape and none of the tax. Either way, you need to know this is happening because the rules could change dramatically in the next 6 to 12 months. Here's what most people get wrong. They think this $0 tax means these items are unregulated now. Wrong. You can still go to federal prison for 10 years if you possess an unregistered suppressor or short-barreled rifle. The registration requirements didn't change. Only the tax changed. So don't get confused and think you can just go buy these items like a regular firearm. You can't. Not yet, anyway. Second, we need to talk about what's happening in California on April 1st. If you live in California or you're planning to visit with your concealed carry permit, listen up. A new law called AB 1078 goes into effect on April 1st, 2026. This law limits you to buying 3 firearms per 30-day period. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Back to California. For a while, California had no purchase limit at all because a federal court struck down their old 1 gun per month rule. But now they're back with a new law, 3 guns per month starting April 1st. Here's why this matters even if you don't live in California. This is the trend. Oregon and Washington are trying to pass similar laws right now, and California's laws have a way of spreading to other states. So what happens in California today might be coming to your state tomorrow. The other big part of AB 1078 is changes to concealed carry permit rules in California. The law updates California's CCW system to comply with the Supreme Court's Bruin decision. But it also adds new restrictions about where you can and can't carry even with a valid permit. If you're carrying concealed in California, you need to understand that even with a permit, there are dozens of places you legally cannot carry. Schools, government buildings, hospitals, and many private properties are off limits. And the penalties are real. We're talking misdemeanor charges, losing your permit, and in some cases, felony prosecution. So if you're a California resident or you're traveling through California with your concealed carry permit, April 1st is your deadline to understand these new rules. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Seriously, those 5 words could be the difference between going home and going to jail. Third, let's talk about the Supreme Court case that could change everything about where you're allowed to carry. The case is called Wolford versus Lopez. The Supreme Court heard arguments on January 20th, 2026. That was just a few weeks ago. Here's what this case is about. Hawaii has a law that says if you have a concealed carry permit, you cannot bring your gun onto private property that is open to the public unless the property owner gives you explicit permission. So that means restaurants, stores, shopping malls, gas stations. Basically anywhere a business operates. You can't carry there unless there's a sign that says guns are welcome. This is what gun rights groups call the vampire rule. You know how a vampire can't enter your home unless you invite them in? Same idea. You can't carry on private property unless you're specifically invited. The plaintiffs in this case argue this rule makes concealed carry permits almost worthless. Because where can you actually carry? Just on public streets and sidewalks? That's not much of a right. Hawaii argues that private property owners have always had the right to control what happens on their property. And if a business doesn't want guns inside, that's their choice. Here's where it gets interesting. The Supreme Court's decision in this case will affect way more than just Hawaii. At least 10 other states have similar laws. New York, New Jersey, California, Maryland, and others. If the Supreme Court rules that these default prohibition rules are unconstitutional, millions of concealed carry permit holders will suddenly have a lot more freedom about where they can carry. But if the Supreme Court upholds Hawaii's law, expect more states to pass copycat legislation. We won't know the final decision until probably June or July of 2026. But this is the case to watch. It's going to reshape concealed carry rights across the entire country. Now, this is where it gets crazy. While the Supreme Court is deciding that case, states are rushing to pass their own laws before the ruling comes out. Hawaii just introduced new legislation to make their rules even stricter in case they lose the Supreme Court case. Oregon is advancing a law similar to Hawaii's, and Washington State is doing the same thing. These states are trying to lock in as many restrictions as possible before the Supreme Court tells them they can't. Fourth, we need to talk about Colorado's new assault weapon law. This one passed in March 2025, and it's creating massive confusion. Colorado now bans the sale, transfer, and purchase of what they call specified semi-automatic firearms. But here's the weird part. If you take expensive training courses every 5 years and pay all the fees, you can still buy these same firearms. I'm not making this up. The law creates a two-tier system. Regular people can't buy certain semi-auto firearms, but people who can afford hundreds of dollars in training courses and government fees can buy them with no problem. What firearms are we talking about? The law targets semi-auto rifles and shotguns with detachable magazines and gas-operated semi-auto handguns with detachable magazines. But .22 caliber rimfire guns are excluded unless they have an upper and lower receiver like an AR-15. And any semi-auto firearm with a fixed magazine that holds 15 rounds or less is excluded. Also, all recoil-operated semi-auto handguns are excluded, so your Glock is fine. But your gas-operated handgun might not be. See how confusing this is? Here's what you need to know if you live in Colorado or you're moving there. The law has a list of specific firearms that are exempted from the ban, but the list is completely random. It includes things like the Ruger Mini 14 Ranch Rifle and the M1 Carbine, but it doesn't include hundreds of other similar firearms. Nobody knows why these specific guns are on the exemption list. It seems totally arbitrary. The law also bans what they call rapid-fire devices. These are any parts or accessories that increase the rate of fire of a semi-automatic firearm. That definition is so broad, it could include aftermarket triggers, lighter springs, or even better ammunition. The law is a mess, and it's already being challenged in court. But here's the bottom line. If you're in Colorado and you want to buy a semi-auto rifle or certain handguns, you now need to jump through expensive hoops. You need a firearms course eligibility card from your local sheriff. That requires fingerprinting and a background check. Then you need to take a hunter education course and a basic firearms safety course within the last 5 years. Or you need to take an extended firearms safety course. These courses can cost hundreds of dollars and take multiple days, and you have to redo them every 5 years if you want to keep buying these firearms. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. It takes 2 seconds, and it keeps you informed about changes like this that affect your rights. Fifth, and this might be the most important one, the Constitutional Concealed Carry Reciprocity Act. This is House Bill 38 and Senate Bill 65. These bills are moving through Congress right now in 2026. If passed, this law would require all 50 states to recognize concealed carry permits from any other state. Think about that. If you have a concealed carry permit from Texas, you could legally carry in New York, California, New Jersey, and every other state. This would be the biggest expansion of concealed carry rights in American history. 24 state attorneys general have signed letters supporting this legislation, and the bill has strong support in the House of Representatives. But it faces an uphill battle in the Senate. Here's why this matters so much. Right now, concealed carry reciprocity is a total mess. Some states recognize permits from dozens of other states. Some states recognize almost none. If you want to travel across the country with your concealed carry firearm, you need to research the laws of every single state you'll drive through. And even then, you might have to unload your gun, lock it in a case, and store it in your trunk when you cross certain state lines. The Constitutional Concealed Carry Reciprocity Act would end all of that. One permit, 50 states. But here's the catch. The bill has been introduced in Congress multiple times over the past decade, and it's never passed. It always gets stuck in the Senate. So will 2026 be different? Maybe. The political landscape has shifted since the Supreme Court's Bruin decision in 2022. Courts are striking down restrictive gun laws left and right. States are being forced to issue more concealed carry permits, and public support for concealed carry is at an all-time high. But even if this bill passes, it won't be smooth sailing. Anti-gun states will immediately file lawsuits challenging it. They will argue it violates states' rights and forces them to accept permit standards they don't agree with. Some states require 16 hours of training for a concealed carry permit. Other states require no training at all. If a person with a no-training permit from one state can carry in a state that requires extensive training, is that fair? That's the argument opponents will make. But supporters say the Second Amendment is a constitutional right, and constitutional rights don't stop at state borders. Your free speech rights don't disappear when you drive from Texas to California. So why should your Second Amendment rights? We don't know yet if this bill will pass. But if you care about concealed carry rights, you need to contact your senators and representatives. Tell them to support H.R. 38 and NS 65, because this could be the year it finally happens. Let me wrap this up. Here's what you need to remember. The NFA tax is now $0, but registration is still required, and lawsuits are challenging the whole system. California's 3 guns per month limit starts April 1st, 2026. The Supreme Court's Wolford versus Lopez decision will reshape where you can carry, and we'll get that ruling by summer. Colorado's assault weapon law is creating a pay-to-play system that might spread to other states. And the Constitutional Concealed Carry Reciprocity Act could pass this year and change everything. This information could literally expire after these laws take effect or get struck down in court. Subscribe now because the next video explains exactly what you need to do before these deadlines hit. And look, I spent hours researching this stuff so you don't have to. The least you can do is hit subscribe to support the channel. Deal? One last thing. This video is for educational purposes only. It's not legal advice. Gun laws change constantly. They vary by state, and they can have serious criminal penalties if you get them wrong. So always consult a qualified attorney in your state before making any decisions about purchasing, carrying, or using firearms. Stay safe, stay informed, and I'll see you in the next one.